Professor Tribe, I know you've been waiting for this decision, as we all have, since the court agreed to take the case in the first place. Can you explain to us why all 9 justices could not read that simple language of birthright citizenship the same way?
Well, they certainly could read it the same way if they were being honest lawyers without any agenda. Nobody took seriously this strange argument that the 14th Amendment doesn't mean what it says, that the language subject to the jurisdiction thereof means something other than being subject to the power of the United States, which applies to everybody born here, unless they happen to be born in a foreign embassy or in a foreign military encampment. They could all read it. But gradually, what sociologists and philosophers call the Overton window, the range of argument that is considered at least worth taking seriously, gradually that shifted. It shifted because Donald Trump and Stephen Miller wanted to find lawyers who would argue this completely ahistorical position, atextual, ahistorical, inconsistent with what Ketanji Brown Jackson rightly described as the second founding of the country. They wanted to find lawyers who would read it in this odd, different way. And sure enough, they did. I didn't expect this decision to be unanimous. Even before the argument, we knew that there were indications in some of the writings of Clarence Thomas in particular, but also Samuel Alito, that suggested they might come up with some way to agree with the revisionist lawyers. What we did not know, what I think very few people predicted, was that on the basic constitutional issue, this court would rule 5-4. In fact, a lot of the reporting of the decision misses the point. Some of them say, well, it was 5.5 to 3.5 because Justice Kavanaugh dissented only in part. No. He was very clear on the constitutional question. He agreed with Clarence Thomas and with Justice Gorsuch and Justice Alito. And so 4 Supreme Court justices, just couldn't seem to read the language or the history the way anybody who has studied this subject outside the context of wanting to please Donald Trump and the revisionists understood it to mean. So it was 5-4. That means that we are a heartbeat away from basically repealing the core part of the 14th Amendment, the part that defines what America is, that America is a nation where each human being is valued for him or herself, where it is not who your parents were or where they came from, but who you are. Were you born here? Then you're a citizen. Were you naturalized? Then you're a citizen. It's not a matter of ancestry. It's not a matter of ethnicity or race. And I think Justice Jackson hit the nail on the head when she said it's supremely ironic for the justice who most vividly insists that ours is a colorblind constitution to transmute what was a fundamental principle about being an American into a race-specific remedy for a racially odious decision, Dred Scott v. Sanford. 5-4. It's really, that's the news. That's the sad news.
Justice Alito seems to think that the invention of the jet engine should therefore have changed the Constitution because he believes now that it's just too easy for a pregnant woman to get on a plane and get to this country and give birth in this country and thereby obtain citizenship for that child. But he should know that his ancestors were and ours were coming over to this country on ships. Now, for hundreds of years, pregnant women were arriving on these shores for hundreds of years from impoverished places on the planet, hoping that there might be more food here than the place they left.
Well, that's true. And he's discovered something that most people have known for hundreds of years. Yes, a pregnant woman can come to the United States of America, have a baby, and that baby is an American. If he doesn't like it, he can propose a constitutional amendment that would get rid of it. But you don't get rid of it by executive order. You don't get rid of it by statute, which is something that Justice Kavanaugh seems to think you could do because he doesn't think the Constitution means what it says. The fact that somebody can come here and have a baby and the baby is an American is part of the nature of this country. We are, to that extent, a country that is built on land, not on blood. They have this idea, the revisionists, that it is the DNA or your ancestry, where you came from. We're all equal. They don't seem to understand that, as Justice Jackson pointed out, the point of this language was to ensure that the promise of the Declaration of Independence about equality was a promise that we could really begin to meet. That's why people think of it as the second founding. The great emancipator, Abraham Lincoln, recognized when he read Dred Scott that was a terrible, odious decision, not just because of what it said about slaves and former slaves, not just because it dehumanized Black people in this country, but because it created a caste system. It obliterated the idea that all people are equal. This core idea that the Declaration of Independence said was self-evidently true. But it's not self-evidently true, it seems, to those justices who want to reconstruct a hierarchical society. In fact, the dissenters accuse the Chief Justice and Justice Ketanji Brown Jackson and Justice Barrett and Justice Sotomayor and Justice Kagan of a return to feudalism because they make things turn on the land. They don't seem to understand what feudalism is. The ahistorical character, as well as the legally blind and illiterate character of the dissenting views in this case, is astonishing, but it is frightening because it represents the views of all but one. It's views of 4 justices. All it takes is a shift of 1. That's why I think we really have to think seriously about reforming the court when we have the votes to do it, because the court is now stacked in a direction that is profoundly ahistorical, profoundly anti-constitutional.
Harvard Law Professor Laurence Tribe, thank you very much for starting off our coverage tonight.
Thank you for having me, Lawrence.